Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review, and my name is Jim Santelle. I am your host on this broadcast throughout the broadcast stations of Civic Media in Wisconsin and throughout the nation. Delighted and honored, as always, that you have selected, you made the choice to spend some time with my producer, Max, and me as we discuss those major issues, those events, those developments in the areas of the rule of law, the delivery of justice and government, locally, statewide, and nationally. This broadcast this weekend, no exception to that, once again adopting and promoting our mission here on Amicus, a law review, of being quite literally a friend to the community, regardless of political perspective, regardless of partisan views about the world, providing information and insight and perspective that is helpful to an understanding of the world in which we live, the livelihoods that are animated by these events in the areas of the rule of law, so that you can make your own decisions about your government, about the ways in which you participate in our lives and our livelihoods throughout the state and throughout the nation as well. This broadcast this weekend, no exception to that, we are going to be spending a good deal of time, as we often do, providing some information, almost some law school-like instruction, once again, based upon a major development right here in the state of Wisconsin. You know what that is. That is the arrest on Friday of this past week of a sitting Wisconsin Circuit Court judge. Her name, Hannah Dugan. We're going to talk about both substance there, what she has been charged with. We're also going to spend some time talking about process and procedure, and that's where the law school portion of this comes in, the civics aspect of our broadcast. Going to be describing for you some of the federal criminal rules that apply, some of the statutes under which the judge has been charged. Yes, indeed, 2 felony counts in the federal system. We'll talk about how that played out, the process by which he was brought into federal court, then released, and we'll talk then a bit about what happens next. All of that in anticipation of some commentary from me, not only about the method by which this matter proceeded, but the specifics in terms of the decision to arrest, focusing specifically upon the standards by which federal prosecutors, state prosecutors, both under the statutes and under the general rules of principles of criminal prosecution, proceed when it comes to making decisions about whether to arrest a defendant or summon that person in for the initiation of proceedings. We'll talk all about that. Necessarily, we're going to begin our broadcast today, however, with the other breaking story as we gather together this weekend, and that is the funeral of Pope Francis. And you might be saying to yourself, gosh, why is that a rule of law issue? Why is that a government issue? What does that have to do with the administration and the delivery of justice? And the answer is a whole lot. All of you know that this Pope was certainly the head of the Roman Catholic Church, not just there in Rome, of course, but throughout the face of the planet. But he was also the head of state, not just in Vatican City, but also a leader on the world stage. We'll talk about some of the issues that he promoted, that he articulated during his 12-year term as Pope, and that do, in fact, have an impact to this day and beyond for many years, maybe even generations, on the administration of justice across the planet. We'll talk about that and focus in particular upon the other major issue that we'll get to probably in the second hour of our broadcast, and that is this Pope's commitment to immigrants and migrants, himself being the product of a family that came to South America. We'll talk about the things that he said, his advocacy, his outreach to communities around the world. And so that is necessarily where we begin with our broadcast. We're also in our second hour going to get to some of our more routine but equally important issues having to do with other things going on in federal courts. We know, for example, that there was a major sentencing in Highland Park just this past week, 2022, the mass shooting that happened there. We'll talk about the dramatic yet highly appropriate sentence imposed upon the shooter just this past week. We'll talk about the the sentencing of George Santos, the former representative, and the impact that that will have upon our nation, as it always does when it comes to the sentencings of public officials. We saw that not too long ago in connection with the sentencing of a senator from New Jersey. We'll talk as well about the recent conviction of Nadine Menendez, his spouse, anticipating her sentencing. Then we'll also talk, again, mentioning in the category of rule of law snapshots, a recent decision by a jury in connection with a defamation lawsuit brought by Sarah Palin, former governor of Alaska, and also a former candidate for the vice presidency of the United States of America. Necessarily, again, time permitting, there is a lot, and it is a lot. We'll necessarily return to our recurring project, which is to identify for you under the heading injunction function, the continuing work, the continuing bastions provided by our federal district court judges in responding to the flurry of executive orders entered by our president. This week, talking about two of the many injunctive orders issued by federal judges, one of them having to do with public school funding, the other one having to do with that very famous executive order issued by the president a while back, seemingly attempting to regulate federal elections, and in particular requiring proof of citizenship, according to Donald Trump. We'll talk about what judges have done in that area, and then necessarily returning to another matter that's often in the news, necessarily focusing upon, yes, indeed, migrants, as the Pope has throughout his career talked about them. That issue remains current to this day. We'll talk about those 238 Venezuelan immigrants now in prison in El Salvador. Talk about one of them who continues to be the focus of a judge named Paula Zinnes in Maryland. You know his name well. We'll also talk about yet another deportee identified just as Christian, who again may have been deported by this government, by our Department of Justice, by our Homeland Security, without proper legal foundation. All of that coming up and more. And the more, of course, is, as always, your contributions to our discussion. We especially invite, Max and I, your questions and your inquiries, especially as we get into some of the specifics about process and due process in our nation. What does this mean? How does this all play out? We invite, we encourage, we solicit, we welcome your comments, your questions, your observations about how this works, how the rule of law works in our nation, in our state, and even locally. And that phone number, of course, is 855-752-4842. One more time, that's 855-752-4842. Max also reminds me that you can drop a question or an inquiry into our chat box as well. Go to Civic Media, find our broadcast, and let us know once again about your specific inquiry, your thing that is prompting you to wonder out loud how this works. We'll talk about it. Also, of course, inviting your observations, as we always do. We appreciate and value so much the contributions made every single broadcast by our listeners. And even if you choose not to be a part of our direct conversation on air, appreciate and value the listening that you do, because it does indeed animate me. It animates Max. It animates Civic Media when it comes to providing information about the world in which we live. Again, ensuring that you have the necessary information, hopefully in an apolitical, nonpartisan way, so that you can make decisions of your own, make judgments, discretionary value assessments about what's going on in the world, and that's what we're all about. And so let us begin. Let us begin with this edition of Amicus, a law review. Friend to you, friend to the people of our nation and our state. We begin, of course, by recognizing and acknowledging. Perhaps some of you got up early here in the state of Wisconsin and beyond throughout the United States and observed by television, by the broadcasts of virtually every news station and beyond, the very solemn but the majestic funeral that happened earlier today on the steps of St. Peter's Basilica there in Rome. The Roman Catholic Church, again, laying to rest Pope Francis. He is, of course, as you know, is a pope of many firsts. He is the Pope who, again, is the first from the Society of Jesus, the Jesuits. He's the first Latin American, the first from the Americas, and the first from the Southern Hemisphere. He comes from Buenos Aires, and he's the first pope raised outside of Europe since 8th century Syrian Pope Gregory III. A lot of firsts there. And again, just this morning, earlier today in Rome, they're about 7 hours ahead of us, laid him to rest. And so it is important because not only of the significance of this as a news story, but also, as I indicated, because he is a man of state. He is a leader in the national and international discussion of major issues. It is significant that we talk about the legacy of Pope Francis, even as we think about what is to come with respect to the leadership of the Roman Catholic Church. The ceremony, of course, including, of course, Gregorian chants, Latin verses, reverberating throughout the piazza. About 250,000 people marching by in recent days, waiting long lines to say farewell to the Pope. Body dressed in red vestments and scuffed black shoes as he lay in state before the basilica's altar for many days before hundreds of thousands again this morning filled and spilled out into St. Peter's Square, streamlining along the long avenue. Those of you who've been there, along the Tiber River there. The funeral, of course, including heads of state, including our own president, Donald Trump is there. Volodymyr Zelensky is there as well from Ukraine. They had a discussion, again, underscoring that politics and government and the operations of state are also a part of this bringing together of chiefs of state. Those leaders, again, gathering there, the body of St. Francis, of Pope Francis, rather, who died again at the age of 88 on Monday. And again, the important aspect of what is going to be happening next and is underway right now is that the papal coffin, loaded into a customized white vehicle, is driving through Rome, goes through Rome and past crowds of once again, thousands of people. Their hands, according to the reporting and according to the viewing of this, of course, shouting great as that cavalcade moves forward, the white vehicle. Francis being buried in a private ceremony in a tomb with the one-word inscription, Franciscus. Franciscus, he is buried at the Papal Basilica of St. Mary Major in Rome. He indicated long before his death that he would go there before and after any of his trips to pray, and so appropriate that he would be laid to rest there, entombed there on this day when we recognize Pope Francis. When we come back, we'll talk more about the things that he said and his legacy when it comes to immigration and immigrants and migrants in particular here on Amicus, a law review. My name is Jim Santelle, and this is Amicus, a law review, coming to you from Radio Park in Racine, broadcast station of Civic Media. Delighted, honored to have you with me this weekend, as every weekend, as Max and I talk with you and engage with you on the important issues of law and justice and government, spending some time appropriately in our broadcast initially this weekend talking about the funeral for Pope Francis, concluded now in Rome. Many of you watched it in the early morning hours here in America, here in the state of Wisconsin as well. Pope Francis, December 17th, 1936, born and died on April 21, 2025. Now laid to rest at the Papal Basilica of St. Mary Major in Rome, along with many other popes of our history. Pope Francis, of course, eulogized as well by Cardinal Giovanni Battista Re during the course of the ceremony, the service today, identified as a pope among the people. The cardinal said, with an open heart towards everyone, he said the guiding thread of his mission was also the conviction that the church is a home for all, a home with its doors always open. And indeed, to that eulogy and that statement about who this pope was, Pope Francis, we know, was a strong advocate for, among many, many other things, migrants and refugees, often speaking about policies related to mass deportations, advocating and for asylum seekers and for more asylum laws to ensure the integrity of the human spirit, the human condition. He is the son of Italian immigrants in Argentina. He frequently drew on his own experiences, his own family history, to emphasize the dignity of those who cross borders in search of a better life. Obviously, an issue much relevant to us here in America, to other nations on the face of the planet. Pope Francis consistently highlighting all a part of his speeches, the human cost of migration. He emphasized repeatedly the importance of treating migrants with dignity and compassion, frequently criticized policies of governments, other heads of state that led to mass deportations, frankly, quite critical of our current president and this administration's policies. They viewing those policies as a violation of human dignity, of basic human rights. He frequently criticized those policies that led to mass deportations and called for more generous and humane asylum laws throughout all nations. He viewed them once again as important to promoting the human spirit. Again, he recognized the global nature of migration. The global nature of migration called for a response that is, in his words, human, just, and fraternal. He personally visited refugee camps throughout his 12-year term as the Pope. He met with newly arrived migrants on a regular basis and even brought 12 Syrian Muslims to Rome after visiting a refugee camp in Greece a number of years ago. All of that a part of his legacy, again, having to do principally with migration and immigration issues, but also many other things on his docket. We know those well. He advocated as well for climate change, also bringing to that discussion an awful lot of review and analysis of what nations around the world are doing to preserve the future of our planet. He was involved in that intimately. He criticized consumerism and what he called overdevelopment. He opposed the death penalty, dead stop, opposing the death penalty under all circumstances. He, of course, was an advocate for impoverished people, opposed their oppression by governments. He condemned past and recent war crimes in places like Europe and the Middle East. He encouraged, of course, the role of women in society and even inside the church. And yes, he advanced openness to the LGBT communities throughout the world as well, significantly promoting a human rights agenda that focused again upon immigrants and refugees. He called that a duty of civilization, his words. And so we think and we are thoughtful this broadcast, this weekend, this time, this week, this year, about the legacy of Franciscus, Pope Francis, as he is laid to rest in Rome this day. And we will certainly revisit the kinds of things that he talked about later in this broadcast as we revisit what our own nation is doing in connection with migrants and immigration. Plainly, one of the challenges here in our nation is the apparent incapacity of our own legislature to address uniform and across-the-board immigration reform, desperately needed, acknowledged by people of all partisan backgrounds and viewpoints, something that our legislature proposes on a routine basis and advances sometimes, but is not accomplished. We still need that omnibus kind of immigration reform. Yes, some movements made in recent years, but not the kind of colossal across-the-board addressing of immigration issues of the sort that the Pope advocated for. And so we think about him, we think about the future of our nation and of immigrants and all these other issues that were a part of his history. Pope Francis, again, being laid into his tomb today, laid to rest today in Rome, as we think about other issues on our agenda, the rule of law agenda, the justice agenda, the government agenda, necessarily then turning to the other major issue that broke this past Friday, plainly percolating for a while, having to do with the decision by the Department of Justice, presumably also by the United States Attorney's Office in eastern Wisconsin, to arrest a sitting judge, Wisconsin Circuit Court Judge Hannah Dugan. We're going to talk about the circumstances of that. I'm going to tell you a little bit more about her. We're going to talk about the mechanism by which she was arrested. How did that come about? I'm going to provide you in some detail with exactly what it is the government is alleging so that you can understand from the very document, the very thing, the piece of paper that was presented in court that charges her with 2 felony counts under the federal law. We'll talk about that. And then some commentary from me, former U.S. attorney, 30 years as an assistant U.S. attorney, 6.5 of those as the United States attorney, both court appointed and presidentially appointed, about the mechanisms through which decisions like this are made, focusing in particular, and yes, you're going to hear criticism and objection from me about the manner in which this particular matter, once a decision was made to prosecute, to bring her into the justice system, and that is the arrest, the physical arrest of a sitting judge brought into federal court in that custodial setting. We'll talk more about that. Let us begin, however, be providing you with some general sense of what the news is and then get into great detail about the specifics in this case. FBI agents, Federal Bureau of Investigation agents, joined by others, arrested Hannah Dugan. She is Wisconsin Circuit Court Judge for Milwaukee County. She is a trial judge sitting here in Milwaukee County, one of the many counties, of course, in the state of Wisconsin. Friday morning in the parking lot there of the Milwaukee County Courthouse, charges of obstructing immigration agents. We'll get into that in greater detail, saying that basically she directed an undocumented immigrant who was appearing in her court on a criminal matter through a side door in her courtroom while the agents, the federal agents, waited to arrest him in an adjacent hallway and in the courthouse generally. The decision, of course, to charge and to arrest Judge Dugan, of course, heightening this focus of this administration on all sorts of issues related to deportations, because at the core of this is a defendant. His name is Eduardo Flores Ruiz. He is a citizen of Mexico, again, according to all of the reporting, who is subject to deportation. The issue, of course, is what happened in the wake of his appearance just this past week. What happened with the judge? How did the agents behave? How did the chief judge respond? How did the federal magistrate respond? How did the lawyers in this case likewise engage in this case? All of that coming up in great detail here on Amicus, a law review. Thank you for joining me and Max for our discussion this morning, a review, a reporting on this major story coming out of Milwaukee, Wisconsin, just late this past week, having to do with the decision by the United States Department of Justice, U.S. Attorney's Office in the Eastern District of Wisconsin to arrest a sitting Wisconsin Circuit Court judge. Her name is Hannah Dugan. Again, the allegations are that she violated federal law. Let's talk about that. Let's talk about the process. Let's talk about the substance of what this case is all about. Let's begin with a little bit about Judge Dugan. She is a graduate of the University of Wisconsin Law School in 1987. She is 65 years old. She has spent much of her career prior to taking the bench serving on behalf of many, many kinds of clients in the areas of housing and public benefits, Social Security cases, a lot of pro bono work, a lot of things involving charitable causes and focuses. Executive Director of the Catholic Charities of Southeastern Wisconsin, also served on the Milwaukee County Ethics Board. During the course of one of her campaigns, she notably said, "Justice is hard work. Everyone knows that." And indeed, that is one thing that we can perhaps all agree on. Justice is not easy. She acknowledges that. She was elected by a wide margin to the bench in 2016. She beat an incumbent judge who was sitting at the time, was unopposed for re-election in 2022, and her current term expires in 2028. A little bit about Judge Hannah Dugan. Also, I should note, as we begin our discussion of this major story, that I know Judge Dugan well. She is a friend with a small f. I want to let all of our listeners know about that. We have had a professional and even a friendship relationship for decades. She is very much a person of the community, which is also relevant to some commentary that I will offer in a few moments, in a few later segments of our broadcast. But I know her well. I have not practiced in front of her, but knew her both as a private practitioner and then see her and sometimes participate with her in various programs, initiatives, presentations, speeches in the community. She is a part of our community as well. And as late as a few weeks ago, she and I were together with many others talking about civics, talking about constitutional rights, and talking about many of the things we discuss on this broadcast. And so I know her. And I, again, want to let you know that as we talk about these particular events having to do with her arrest, her charging in the federal system by my now former office, the U.S. Attorney's Office in Eastern Wisconsin, and the agency for which I worked for 30 years, that is the United States Department of Justice. So, Hannah Dugan, a defendant now in a case called the United States of America versus Hannah Dugan. She is charged with two felony counts. It is always significant. This is not a matter that federal prosecutors simply identify descriptively what a particular defendant has done, allegedly in violation of the law, but they identify particular statutes. In this case, it's 18 U.S.C. section 1505. That is obstructing or impeding a proceeding before a department or agency of the United States. The second charge is brought under a second statute. It's 18 U.S.C. section 1071. That's concealing an individual to prevent his discovery or arrest. Let's talk a little bit more about those two statutes in particular. 1071, again, concealing a person from arrest. It says basically this: whoever harbors or conceals any person for whose arrest a warrant or process has been issued under the provisions of any law of the United States so as to prevent his discovery and arrest after notice or knowledge of the fact that a warrant or process has been issued for the apprehension of such person shall be fined and otherwise pursued, prosecuted under this particular statute. It is a felony. It carries with it a fine. It carries with it imprisonment for no more than 5 years or both. That's section 1071, concealing a person from arrest. That's one of the bases, the statutory bases. Again, all of these pieces of law here passed by the legislature, our federal legislature. Then we've got section 1508. It is also significant because it's the other one that contemplates prosecution for obstructing or impeding a proceeding before a department or agency of the United States. And so what is that all about? It is a longer statute, but it basically says this: whoever corruptly or by threats or force or by any threatening letter or communication influences, obstructs, or impedes or endeavors to influence, obstruct, or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States, or the due and proper exercise of the power of inquiry under which this investigation is being had, that person also subject to prosecution under this statute, section 1505, likewise carries with it fines, imprisonment of not more than 8 years. Those are the two statutes. Those are the two statutes under which the Wisconsin Circuit Court Judge Hannah Dugan has been charged. Now, how has that happened? What is the process by which this happened? How is it that those federal agents and others arrested Hannah Dugan Friday morning in the parking lot at the Milwaukee County Courthouse? Well, they were acting pursuant to a criminal complaint. And you may say, well, gee, Jim, haven't we always talked on this broadcast and other settings about the right of every single person under our Constitution? If you are charged federally, didn't James Madison, doesn't the Fifth Amendment to the Constitution guarantee that indeed someone who's charged in the federal system will be subject to due process and all of those other things only upon presentment, as the Constitution says, or indictment of a grand jury? And there are exceptions to it. And that's what Amendment 5 to the Constitution says. Presuming that any charges coming out of your federal government, doesn't apply to states, but the federal government will come out of a grand jury. 23 people, as we've talked about at such great length in the past, brought together. They are you. They may not be me, but they may be you, others in our community, brought together to decide whether or not the government has established, and here's the first standard to think about, probable cause. Not proof beyond a reasonable doubt, that's a trial standard, but probable cause to believe that a crime has been committed. And so what happens in front of a grand jury, private proceedings, not a part of the public domain, unlike a trial and juries in a petit setting, P-E-T-I-T, a trial, that's public, but the grand jury is not. The grand jury proceeds in a private setting to determine whether the evidence presented before them, yes, by the U.S. Department of Justice, yes, by federal agents, sometimes, often by citizen witnesses as well, but by assistant U.S. attorneys who are presenting evidence, the first step in moving forward on a criminal prosecution. The grand jury has this tremendous responsibility to determine whether or not a particular case should proceed, whether an indictment should issue, whether the government has established, not proven a case beyond a reasonable doubt, but established, provided enough evidence to believe that there is probable cause that an offense under the federal statutes has existed. In this case, eventually, one way or another, we'll get to that, a federal grand jury necessarily is going to have to review the evidence that has already been presented somewhat in this criminal complaint, and that will be their responsibility. The federal Constitution still ensures that if this case is to go ahead, a federal grand jury must pass on the evidence, make that initial determination, and decide yes or no, should an indictment issue. But before that happens, and so you may ask, well, gee, why doesn't that happen right now? Before that process kicks in circumstances where there is a need, based upon the exigencies of the investigation, based upon the particular findings of the investigative work to that date, to move more quickly. Grand juries meet in courtrooms and courthouses throughout this nation on a weekly basis. But when things happen, and as you well know, crime happens very quickly, sometimes in the dead of night, sometimes in the brightness of day, but often requiring that charges be issued more promptly than even a grand jury can get to. Under those circumstances, the federal rules of criminal procedure provide a mechanism that predates, if you will, anticipates a grand jury proceeding to ensure that the process goes ahead. And that's the criminal complaint process. It is a system whereby, again, upon presentation to a federal magistrate, again, not the grand jury, but a federal magistrate or a federal judge, the government, in this case, the U.S. Attorney's Office, the Department of Justice, presents to that judge, that judicial officer, information, the results typically of an investigation that suggests that this person, that indicates that this person reflects that the person or the entity, you can also charge a corporation, of course, has engaged in crime. And the standard is the same. It's probable cause. And if the judge reviews that information presented typically by an agent upon a sworn affidavit that this is the result of the investigation that I, as that agent, have conducted and pursued, if at the end of that, the judge makes the independent, non-Department of Justice determination, the independent judicial determination, that indeed there is probable cause in the four corners of this presentation, made typically in writing, can also be oral, but almost always committed to writing. If that magistrate judge, if the federal district judge determines that there is probable cause, that magistrate judge then can issue a criminal complaint. It is typically, of course, endorsed and presented and even advocated for by assistant U.S. attorneys, by the lawyers of the Department of Justice, and done once again, not in violation of the Constitution, but rather pursuant to the federal rules that permit this more expedited charging in a situation where charges need to issue. Often it is the case that federal agents, state agents, may necessarily, in exigent circumstances, arrest a defendant who is engaging in criminal conduct, typically, and this is important, of a violent nature. The need then to react promptly to a bank robbery that has just happened, to some human trafficking, gang activity, guns activities, drugs activity, transactional things like that, that need very prompt attention. A criminal complaint, again, presented in draft form to a federal magistrate or a judge, reviewed by that judge, an agent coming in and swearing on the penalty of perjury that this is the result of the investigation to date. That is the process by which a criminal complaint can issue. And that is indeed what happened here. Again, anticipating that some point down the road, and yes, indeed, the government, whether it is the Department of Justice in Washington, the U.S. Attorney's Office in eastern Wisconsin, located in the federal courthouse in Milwaukee, still has an obligation. This criminal complaint process does not remove the obligation under the Constitution to pursue a criminal indictment, if at all, before a grand jury. It just provides this interim mechanism for accomplishing that. And the obligation, the timing obligation, this again important, is within 30 days of that complaint, presumably of the appearance of the defendant in court in response to the issuing of an arrest warrant, the issuance of that complaint. The government, your government, the Department of Justice, has 30 days to appear before the grand jury and either secure or not secure a formal indictment. During that period of time, also fairly routine. This can be enlarged somewhat upon the agreement of the parties and the order of the court. But during that 30-day period of the time, the defendant also has a right to what's called a probable cause hearing. And at that proceeding, the government has the obligation to come forward in open court and support what it has written about, what the agent has written about in writing. And that also before the magistrate judge, who basically does a secondary look in greater detail at the predicates for that factual finding that probable cause exists. All of that a part of the regular criminal procedure, and that is what's going on here. And so finally, we get back again to this criminal complaint, not a grand jury indictment, not yet, issued again by a federal magistrate judge on the 24th of April. And it's pursuant to, again, and based upon an affidavit. And that affidavit, it is 12 pages long. It is accessible. It is in the public domain. I'm going to provide to you some information about exactly what it says and doesn't say. It is provided by a federal agent of the FBI who comes in and swears to its truth based upon the investigation to that point. When we come back here in Amicus, I'll tell you more about exactly what that criminal complaint says, the underlying affidavit, and then talk about the process that accomplished the arrest of a Wisconsin Circuit Court judge here on Amicus, a law review. This is Amicus Law Review. My name is Jim Santelle. We are necessarily spending some significant time on this, our weekend broadcast, talking about this major rule of law, justice, government story that has broken here in our state, in our nation, and indeed worldwide, having to do with the arrest on Friday of Wisconsin Circuit Court Judge. Her name is Hannah Dugan, talking in great detail now about the process by which this happened, the mechanisms. This is the law school portion of our broadcast, and it's also the civics portion, again, because understanding how this happened, what the process is, and then that also invests in you the capacity to make decisions about your assessment of these things. And yes, indeed, even though these are highly steeped in the processes, the statutes, the regulations, the rules that I've already described, nonetheless, because of the nation in which we live, you have the right and you have the prerogative, if you so choose, to express your own opinions upon the ways in which processes are invoked. And indeed, I will offer some perspectives on that, and in particular about the decision to arrest in just a few moments. This affidavit presented again by a federal agent. Her name is, she's a special agent, named specifically in this 12-page affidavit. She swears to the magistrate judge this is true. It is a compendium of all the work that plainly has been done over the period of the previous week, assembling for the judge. Again, noting that it's not complete. It may not have everything that the government knows, but enough to establish, once again, probable cause. And again, important to underscore the notion that this is not a presentation. This is not a trial. And indeed, that the standard is probable cause. It's not proof beyond a reasonable doubt. That's what the magistrate judge looks to determine whether or not the special agent has established, by virtue of her affidavit, probable cause to believe that in this case, Hannah Dugan has committed violations of the federal law. And indeed, the magistrate, looking at this 12-page affidavit presented to him under oath, made that determination, issued the criminal complaint, issued the arrest warrant that accomplished the arrest of the Wisconsin Circuit Court Judge Hannah Dugan on Friday of this past week. Let me give you some sense and some great detail about what this particular affidavit says. Begins necessarily telling all of us, telling the judge, the magistrate judge, something about who the special agent is. Notes specifically that she investigates public corruption crimes, civil rights crimes, financial crimes. Those typically are not violent in nature, but they can be, and they certainly can compromise, obviously, the rights and prerogatives of many people out there. They're victims as a result of those crimes. She goes on to say the purpose of this affidavit is to establish probable cause under those two statutes that we've already identified here, and then goes on to explain exactly what the basis for this particular decision by the Department of Justice to charge this defendant, the Wisconsin Circuit Court Judge Hannah Dugan, and to seek in particular this criminal complaint against her. Goes on to describe the background of this, identifies, again, Edward Flores as one of the principal actors in all of this. His name is Flores Ruiz, and identifies in particular that the Department of Homeland Security, Immigrations and Customs Enforcement identified Mr. Flores Ruiz as an individual who was not lawfully in the United States, noting again that he was appearing on April 18th in the courtroom of Hannah Dugan. The investigation, according to the special agent, indicates that the investigators, the law enforcement authorities, were aware that on April 18th, Mr. Flores Ruiz was scheduled to attend a hearing in his criminal case, courtroom 615, in front of Judge Hannah Dugan. And that's how she becomes involved in this. Goes on to say that as a result of some further information gathered by the law enforcement authorities, they made a determination that they would indeed attempt to make the arrest of Mr. Ruiz here in that setting, Mr. Flores Ruiz, because of the checkpoints and the other security issues presented by security in the courthouse. As such, the agent says, members of this task force responsible for this action developed a plan to arrest Flores Ruiz in a public area outside of courtroom 615 following his scheduled criminal court appearance before Judge Dugan. Again, an awful lot of background history that gets us to that point. Describes then again the arrival of the arrest teams at the Milwaukee County Courthouse and the notification of intended arrest. Says at approximately 8 a.m. on April 18th, the law enforcement officers, having arrived at the courthouse, presented an identification to a security guard, explained the reasons why they're there. They discussed the details of their planned arrest, including which courtroom Flores Ruiz was going to be appearing. And the sergeant who responded to them asked that any arrest wait until after the completion of the scheduled appearance before Judge Dugan, and the officers agreed. They were allowed to proceed unescorted to the public hallway outside of courtroom 615. Again, more detail about their movement into the courthouse on that morning. The courtroom deputy again explained that at approximately 8:15, again, explaining again to the agent who is plainly investigating this. The agent has unmistakably talked to a lot of people who described then what happened here. Described at about 8:15, FBI agents advised that they were working with ICE and planning to arrest Flores Ruiz. The courtroom deputy asked that the agents wait outside and arrest Flores Ruiz after the hearing. The agents agreed to that, and they left the courtroom. Again, an awful lot more information along the way here about the interactions and the conversations that I'm not describing here in particular, but significantly other things that are disclosed that are not necessarily in the public domain, at least not the media public domain. These are in the public domain of the criminal complaint. Arrest team members reported that while waiting outside the courtroom for all this to happen, a woman approached and she took some photographs of the arrest team members. And one of the agents who was inconspicuously seated away was not photographed. The individual taking photographs of the agents has been identified by some of the witnesses as an attorney employed by the state of Wisconsin, the Public Defender's Office. Again, nothing wrong with that. They note that, however, to further reconfirm the story, the events that are told on that day. Team members observing Flores Ruiz arrive on the 6th floor courthouse at that courtroom at about 8:43. Greeted by his attorney, and the two enter courtroom 615. And that is when we have, after that, the first of two events. Judge Dugan learning of the presence of law enforcement confronting members of the arrest team. And here I am going to read with some greater particularity exactly what the criminal complaint says, because it's important once again to understand what is and is not there in the criminal complaint. Witnesses, again, identified by the agent, have described Judge Dugan's response to learning of the law enforcement presence. For example, the complaint says the courtroom deputy indicated that when Flores Ruiz arrived, Judge Dugan was already on the bench. As we continue in our second hour, I'll tell you more about what this complaint actually says about the interaction between Judge Dugan and the law enforcement officers. We'll talk about the specific events that give rise to this criminal complaint, and then we'll talk about the mechanisms through which all this was executed on Friday of this past week. Stay with us for that discussion and that analysis of the rule of law here on Amicus, a law review.
Welcome to Amicus, a law review with Jim Santelle, Civic Media's weekly review and discussion of some of the most significant news stories in the areas of law, government, courts, and the aspiration for justice. And now, here's your host, Jim Santelle.
This is Amicus, a law review. My name is Jim Santelle, your host. Last hour, this hour as well. Importantly, spending some time in great detail talking about the charges against Wisconsin Circuit Court Judge Hannah Dugan, the mechanisms by which she has been brought into the federal system, and the content of the particular affidavit that supports the criminal complaint against her under these two federal statutes in the Federal Criminal Code. Important to appreciate exactly what it is the allegations are. Important in the same breath to understand that these are allegations, and that although a magistrate judge has found probable cause to believe that offenses have been committed by the judge under these particular statutes, the defendant in this case, yes, Wisconsin Circuit Court Judge Hannah Dugan, is presumed innocent. And that attends her throughout the entire proceeding, including proceedings that will happen in the days and weeks just ahead. The finding of probable cause is not a determination in the end, not a criminal judgment. It is a finding that the case can proceed based upon the representations, the presentations made to the judge. And that's where we continue at this point, providing you with some specifics from that complaint about what happened that led to these charges against Hannah Dugan. As we pick up the story, Judge Dugan on the bench conducting proceedings in another matter. The courtroom deputy, again, obviously having been spoken to by the FBI as a result of this, observe an attorney who's identified as Attorney A. The same attorney was taking some photographs outside in the hallway there. Enter and approach Judge Dugan's clerk. Attorney A stated that there appeared to be ICE agents in the hallway. Attorney A told the clerk where the agents were seated and what they were wearing. The courtroom deputy then reported that the clerk then got up and talked with Judge Dugan. And here is where the story not only becomes increasingly important, but also descriptive by virtue of what the agents and the people who were there provided to the agents. Says Judge Dugan became visibly angry, commented that the situation was absurd, left the bench and entered chambers. At that time, Eduardo Flores Ruiz, who was going to be the subject of the criminal proceeding there, again, he was there to face some domestic violence charges. He was seated in a gallery of the courtroom. There was another person, Attorney B, who was working as an assistant DA. That's very typical in the courtroom on April 18th. And according to Attorney B, there were approximately 8 criminal cases altogether, including Flores Ruiz's case, scheduled for pretrial proceedings that day. Members of the arrest team, again, all this according to the complaint, reported the following events after Judge Dugan learned of their presence and left the bench. They say this, and the agent says this: Judge Dugan and another judge, who were both wearing judicial robes, approached members of the arrest team in the public hallway. Judge A's courtroom is located adjacent to Judge Dugan's courtroom. That is this other judge who was there. Witnesses reported that Judge Dugan was visibly upset, had a confrontational, angry demeanor, again, according to the complaint. Judge Dugan addressed the officers who were there and asked if they were present for a court appearance. And when they responded no, Judge Dugan stated that they would need to leave the courthouse and leave the area. Law enforcement stated that they were there to effectuate an arrest. And Judge Dugan again asked if the officers had a judicial warrant. The officers responded no, they have an administrative warrant. And Judge Dugan said that they needed a judicial warrant. The conversation continues back and forth. There's plainly disagreement here. Deportation officer tells Judge Dugan that the obligation is not to have a judicial warrant. It's a public space, the officer says, has a valid immigration warrant. And Judge Dugan asks to see that warrant and the officer offers to show that to her. Judge Dugan then demands that the officer speak with the chief judge. And that's when this takes another different course of event that day, and had a similar action with an FBI agent at the same time. And after finding out that they were present for not for a court appearance, but rather to arrest the defendant there, the judge, Hannah Dugan, directed they go to the chief judge's office. Now, his name is Carl Ashley. He's an outstanding judge. He's the chief judge of the Milwaukee County Circuit Court. And the other judge, identified as Judge A, escorted then the law enforcement to the chief judge's chambers and his office, again, on the 6th floor. Again, skipping over some of the affidavit. The affidavit goes on to say, once at the chief judge's office, the law enforcement showed Judge A the credentials, the administrative warrant, and the judge who had accompanied those officers to the chief judge's office asked the clerk to make a copy of the warrant, asked whether the chief judge was available. Clerk advised that the chief judge was not in the building, but later advised that he was in fact there and on the phone. At that point, the other judge left, and the law enforcement went inside for a more private area of the chief judge's office to speak with him on the phone. During that conversation, and this is significant because we know this has been going on, the chief judge, again, according to the affidavit, stated that he was working. He was working on a policy that was going to address specifically these kinds of things. Indeed, we know this from the general media, a policy which would provide information and protocols and practices for accomplishing arrests inside the courtroom in a way that would be efficient but also safe and secure. He said it's a policy that would dictate locations within the courthouse where federal law enforcement, including ICE, could safely conduct enforcement actions. According to the affidavit, the chief judge emphasized that those actions should not take place in a courtroom or other private locations within the building. And the law enforcement officer asked about whether the enforcement actions could take place in the hallway. And the chief judge indicated that hallways are indeed public areas, authorized to do it there. The chief judge expressed interest in talking more to management about this policy. And indeed, that is what Judge Ashley has consistently been about in his role as the chief judge, putting together this policy that addresses exactly what was going on when he was presented there with this conversation by the law enforcement officers. And then finally, we get to the focus of the charges against Judge Dugan. Multiple witnesses, according to the complaint, described their observations after Judge Dugan returned to her courtroom after directing members of this arrest team to spend some time with the chief judge. For example, according to the affidavit, the courtroom deputy recalled that upon the courtroom deputy's return to the courtroom, defense counsel for Mr. Flores Ruiz, again, he is the defendant who is there to have discussion about the domestic violence charges against him, was talking to the clerk, and Flores Ruiz was seated in the jury box rather than in the gallery. The courtroom deputy believed that counsel and the clerk were having an off-the-record conversation to pick the next court date. Defense counsel and Flores Ruiz then walked toward each other and toward the public courtroom exit. The courtroom deputy then saw Judge Dugan get up, and she heard Judge Dugan say something like, "Wait, come with me." And again, according to the affidavit, despite having been advised of the administrative warrant for the arrest of Flores Ruiz, Judge Dugan then escorted Flores Ruiz and his counsel out of the courtroom through the jury door, which leads to a non-public area of the courthouse. And those events were, again, according to the affidavit, were also unusual for two reasons. It identifies first, the courtroom deputy had previously heard Judge Dugan direct people not to sit in the jury box because it was exclusively for the jury's use. And second, according to the courtroom deputy, only deputies and juries and court staff and in custody defendants being escorted by deputies use the back jury door. Defense attorneys, defendants who were not in custody never use the jury door. Again, as a part of the conduct here described in the complaint, the attorney similarly explained after returning to the courtroom that Judge Dugan forcefully motioned to Flores Ruiz's attorney, and made a male that she did not know. Apparently, Attorney B had never met Flores before, to approach the bench. And Flores' attorney, again, according to the complaint, appeared to be confused by the judge's gesture, but complied nonetheless. Judge Dugan commanded Flores Ruiz's attorney, and the male, again, with the attorney, of course, to leave through a back door of the courtroom. Attorney B then saw Judge Dugan escort Flores Ruiz's attorney and the mail through the non-public door near the courtroom's jury box. Obviously, that mail, not previously known by the other attorney, B, is Flores Ruiz. Judge Dugan came back to the courtroom, conducted hearings that morning on her docket, and later that morning, Attorney B realized that Flores Ruiz's case had never been called and asked the court about it. Attorney B learned that Flores Ruiz's case had been adjourned, and that happened without the attorney's knowledge or participation. All of this, according to the affidavit, in great detail. Now, in the remaining pages and paragraphs of the affidavit, it is lengthy. It is 12 pages long. The agents go on, and the FBI agent in particular describes that Ruiz eventually makes his way out of the courthouse. He is arrested after a foot chase outside the courthouse itself. He is brought into custody. And all of that, again, described in this 12-page affidavit, concluding with, based upon all of this information, I, meaning the special agent, I provided probable cause. I have probable cause to believe that Judge Dugan violated these two statutes, Section 1505 and Section 1071 of Title 18, that we discussed in the first portion of the broadcast today. That's the criminal complaint. That's the substance of what the government alleges. Again, these are allegations. It is the basis upon which, to be clear, once again, the federal magistrate judge has found probable cause, the first step in this process to initiate a criminal action of this nature, and also plainly authorized an arrest warrant based upon that same affidavit, and giving authorization to the agents to go last Friday morning to the courthouse to effect the arrest of the circuit court judge as she was arriving there. Now, once again, as we said during the course of our first hour here on the broadcast, there is more process to come. What happens, of course, is that in the wake of this, the government now does have an obligation to participate in a probable cause hearing. The magistrate judge has scheduled that, other proceedings for May 15th, just a few weeks from now. The government also has an obligation of the Constitution, as we said, if it chooses to do so, to seek a formal indictment before a grand jury. Again, a criminal complaint of this sort, basically in existence for 30 days. It is intended not as a stopgap, but to address instances of criminal conduct that need immediate attention, because there's something about them that requires that the defendant or defendants be brought into the custody of the court. When we come back, we'll talk about what happened in front of the magistrate judge. We'll talk more about that arrest in particular, and my own observations and criticisms and objections to the way in which the Department of Justice executed on these documents. All of that when Amicus, a law review, continues. is Amicus, a law review, necessarily spending a great deal of time in our weekend broadcast talking about this major rule of law justice issue, this development, this event having to do with the arrest, getting national, indeed worldwide attention, the arrest of Hannah Dugan, a Wisconsin Circuit Court judge, last Friday upon this criminal complaint, these initial charges by the Justice Department, by the U.S. Attorney's Office, by prosecutors, federal criminal prosecutors, who believe, based upon the affidavit and the information provided, that Hannah Dugan has violated the federal criminal law, and this is how the process begins. Well, how does that process continue? Well, we know that after the magistrate judge, again, found probable cause, issued this criminal complaint, also issuing an arrest warrant. And that is the authorization by which the federal agents actually arrested the judge in the parking lot on Friday morning, brought her back in custody. Significantly, very troublingly, the director of the FBI, his name is Kash Patel, posted a picture of the judge in shackles on social media. He also posted other things, which we'll talk about, also equally troubling. But as a result of the issuance of that arrest warrant, the agents have judicial authorization to bring her back to the federal courthouse. That happens, and indeed, promptly she appears before a federal magistrate judge. He is the same one who issued the arrest warrant and the underlying complaint. At that time, of course, the judge appears. She is represented by counsel. The government is represented by two assistant United States attorneys from the U.S. Attorney's Office. And among other things, the charges are read. The affidavit, again, a part of the public record, which I've just described, not in complete detail. There is more to that, which you can also read. It's a part of the public domain. That's a part of our process in the federal system in America. As a part of the system and the hearing in particular, the allegations, the charges on this criminal complaint are read. The plea is entered, and significantly, one of the other most important things that happens in a situation like this is the magistrate judge addresses what we do next. The defendant, in this case, a Wisconsin Circuit Court judge, is in custody. Does the judge release her? Does he continue her detention, her custodial status? What does he do? Well, again, here's where the law school portion of this comes in. There are rules and there are statutes that specifically describe how this is to play about. And the fundamental notion behind Section 3142, that is the statute that talks all about release or detention of a defendant pending trial. It is a lengthy statute, all sorts of subsections, but the fundamental notion behind it is that the magistrate judge, has a number of different alternatives. The judge can either release that person on personal recognizance bond upon a particular variation of that, the execution of an unsecured bond, can secondarily release that defendant on a combination of conditions, circumstances under which that release will be accomplished, can temporarily detain that person to permit revocation of some other conditional release, other things out there, or fourth, can detain that person going forward. There are many alternatives presented to the magistrate judge. And here's the one that's most important, and the thing that animates not only me when I was an assistant U.S. attorney, also those assistant U.S. attorneys who plainly were handling this case on Friday. The question is this: does this particular defendant pose a risk of flight, and or a danger to the community? That's the question that's asked in all of these post-charging, post-complaint, even post-grand jury indictment proceedings. It is set forth in subsection C of Section 3142, commands the magistrate judge to make an assessment of the extent to which this person, this defendant now charged, is either a risk of flight. You're going to leave if I don't detain you. You will not return for future proceedings. And second, determining whether or not that person poses some affirmative danger, some threat to the safety and security of the community. Those are the two analyses. They're set forth in the statute, issued by the Congress, returned by the Congress legislatively, and that is the standard by which federal judges, magistrate judges, and indeed state court judges and others operate. Danger to the community. What threat will this person pose if indeed they are released? And will they return? Are they a risk of flight? Will they get on a plane? Will they leave the community? Will they leave the state, the country? Will we never be able to get them again? And that is the analysis that again prompted this particular magistrate judge plainly, appropriately, reasonably to release Hannah Dugan promptly. Why? Why? On this record, and again, as I said at the outset, knowing well who she is, knowing things that, frankly, the broad legal community in Milwaukee knows about her. We know these things. This is her community. This is where she has lived. This is plenty where she works. She is of this community. And as I said, when I provided you with my own sense of my professional relationship with her, and yes, even a small friendship with her, a small F friendship with her, plainly, she is out there in this community, committed to the issues and events of this community. This is where she lives. This is where she works. The chances that she would flee are virtually non-existent, if existent at all. She is not a risk of flight. Absolutely not. And secondarily, a risk of danger, safety and security of the community being compromised by releasing her? No. And there we make references to other cases. Are there situations where, for example, someone who's just been arrested on a criminal complaint, returned on a grand jury indictment, who's engaged in gun dealing, drug trafficking, money laundering, other things that may compromise the safety and security of the community, sex trafficking, labor trafficking, all kinds of things out there that indeed pose threats to the continuing safety and security of the community, necessary to detain them, because if they are released, they are in fact a threat to the community. Not Hannah Dugan. Plainly not a threat to the community, plainly not a risk of flight. And we note as well other circumstances in our recent events and memories of history of judicial proceedings in our nation. When Donald Trump in recent years was indicted 4 different times, he had appearances in front of the various federal and state court judges who were presiding over those cases. In every one of those, although one could make an argument, as indeed the government did, the federal government did, that there were concerns about the extent to which Donald Trump, at that time, of course, private citizen, would return, questions raised about whether or not he should surrender his passport. But the reality was that in the end, Donald Trump was released. Why? Because he was not perceived as a danger to the community and a risk of flight. Likewise, when others, including, for example, Eric Adams, the mayor of the city of New York, likewise charged by a federal grand jury with corruption. That case ultimately dismissed, as we know, without a huge amount of controversy, and ended up with the resignation of a U.S. attorney in Southern District of New York. When he was indicted, likewise, he appears in front of the federal magistrate judge and applying Section 3142 and these basic standards: no risk of flight and no danger to the community going forward. That is not only significant with respect to this decision of the magistrate judge as Hannah Dugan is appearing in front of him last Friday, but also, and this is where the objection and the concern comes, the decision to arrest her in the first place. When Amicus, a law review, comes back, I'll tell you more about that. And then we'll also be taking any comments, questions that you've got, again, here on Amicus, a law review. Amicus, my producer, in the studios of Civic Media, taking your phone calls as well at 855-752-4842. We'll get to at least one, if not more, of those in the coming segments. Talking necessarily this weekend about the decision by the Department of Justice not only to prosecute, to bring charges initially, again, subject to a return of a grand jury indictment if that happens by a grand jury in eastern Wisconsin. That decision, obviously the focus of an awful lot of attention, decision to choose and to prosecute at all, but also the mechanisms by which this was accomplished. And again, focusing upon the prerogatives that federal prosecutors have about accomplishing the bringing into the system of defendants. That can be done in a number of different ways. And in white-collar cases, in situations where there is no credible belief that the defendant, whether indicted on a criminal complaint or indicted by a grand jury or charged under a criminal complaint, poses a risk of flight, no danger to the community, it is routine. It is regular for assistant U.S. attorneys, for U.S. attorneys' offices around the country to reach out to that defendant, often through her or his attorney, and say, the grand jury has indicted your client or is about to indict your client. And we would like to talk about the circumstances under which there is a voluntary appearance, a voluntary surrender even to the U.S. Marshal without the need for an arrest warrant. Why? Why? Because your particular client, whoever they may be, whatever they have done, the criminal nature of that, typically nonviolent, not in the nature of guns or drugs or gangs or human trafficking, those kinds of things, of a nature that does not pose an immediate threat of violence to the community, doesn't compromise the safety and security of the community, and there's no risk of flight. Fairly routine, very routine, as a matter of fact, for assistant U.S. attorneys to reach out to the defense counsel, to the defendants themselves, and say, let's talk about making this work. Let's talk about bringing the defendant in a, obviously, it's still adversarial, but in a circumstances where arrest is not important, not in a custodial situation. If you agree, for example, to show up next Tuesday morning, next Thursday morning, we will schedule that on before the magistrate judge. No need for an arrest, no need for custodial situations in advance of that. And presumably, we will also agree that you can leave afterwards pursuant to the invocation of, again, Section 3142, contemplating that a particular defendant does not pose a risk of flight, does not pose a continuing, if ever, threat to the safety and security of the community. Many situations where indeed that does not happen. We think again about recent history in American jurisprudence. Luigi Mangione, who just on Friday pled not guilty in the federal court in the Southern District of New York to the offense conduct charged by a grand jury against him. Appropriate there to issue an arrest warrant? Absolutely. Why? He was a risk of flight. He fled the scene of that horrific alleged murder. But the event happened, we know, on the streets of New York, plainly identifying him as the very, very likely a responsible party, the defendant in that case, and also posing a threat to the community. Why? He's got a gun. He did this incredibly violent thing. And under those circumstances, where you've got a risk of flight, you've got a risk to the safety and security of the community, do you issue an arrest warrant and do you execute it by bringing that person in shackles and in a custodial situation, detaining them? The answer is absolutely yes. You do that because of the nature of the violent crime and because of the threat of continued violence. The threat also that if that person is not brought in an arrest warrant, they will continue to flee. The Mangione situation is just the opposite, and it underscores my great concern, my great objection to the way in which this particular matter involving this judge was pursued. If indeed, and it has been made by the folks internal to the U.S. Attorney's Office and presumably by the Department of Justice as well, the strong sense is that Pam Bondi and the director of the FBI, Kash Patel, having a major role to play in this. Pam Bondi also troublingly indicating that this prosecution is a part of the president's plan, his policies, his practices with respect to immigration. Those kinds of things should not be mixed up. She is saying that. Plainly, the director of the FBI posting almost immediately information that may or may not have misdescribed exactly what's going on here, but indicating that this is more than just a local prosecution, a decision presumably having been made to prosecute Judge Dugan at the highest levels of government as a part of the president's immigration policies to crack down on immigrants and to address immigration issues according to the way that he sees them being addressed. We know he's talked about this in other settings. And even inside that decision, even if the decision is made in the end with probable cause to believe that there has been a crime committed here, once you make that decision, then the question necessarily has to come, how do we accomplish this? And the decision was apparently made that Hannah Dugan somehow immediately poses a risk of flight, a threat to the community. There's nothing in this record, nothing even about the affidavit itself that describes her alleged criminal conduct would suggest that. And yet the decision was made to arrest her and bring her into the federal custody, doing the one thing that is, as I've often repeated in other settings, the single most significant thing that a government can do, which is deprive you of your liberty, detain you, even if it's only for an hour or two, even for minutes. In custody is the single most significant thing a government can do to you. Of course, inside that, imposition of the death penalty, the larger issue that a government can impose, that's not here. That's not implicated by this at all. But it also indicates and also reflects upon the important discussion that needed to be had prior to the decision to issue and seek an arrest warrant for her, to bring her in under those circumstances. The apparent decision confirmed by the director of the FBI when he posts a picture of the judge in shackles being brought into the federal courthouse. And one has to wonder aloud about deterrence, right? Deterrence, as we've talked an awful lot on this broadcast, is the kind of thing that you do by virtue of the prosecution itself. If the decision is made to indict Hannah Dugan by a grand jury, that is the decision of a grand jury. That is a decision plainly embraced and promoted by the present Department of Justice, the present interim United States Attorney. And there can indeed be strong disputes about that. Indeed, yesterday afternoon on the steps of the federal courthouse in downtown Milwaukee, I happened to be coming from a class at the time, great numbers of people there congregating to oppose the very decision that was reached internal to the Department of Justice to seek this prosecution in the first place. I would like to add to that the concern about the mechanism by which Judge Dugan was brought into the system, this arrest in particular. We know as well that there's an awful lot of public response to this. We know that Mayor Cavalier Johnson said it sends a chilling effect to other people who participate in our judicial process. When folks do not participate in the judicial process, that makes our community less safe. David Crowley, the Milwaukee County executive, said in a statement that Judge Dugan is entitled to her constitutional right to due process, and then goes on to say this. He says, however, it is clear that the FBI is politicizing this situation to make an example of her and others across the country, an example that you can now see visually by virtue of what the director of the FBI did, who opposed their attack on the judicial system and our nation's immigration laws. And again, that protest outside the federal courthouse Friday afternoon, people gathering there carrying signs reading, "Hands off our judges." We know as well that even the governor of the state of Wisconsin, Tony Evers, said, unfortunately, we have seen in recent months the president and the Trump administration repeatedly use dangerous rhetoric to attack and attempt to undermine a judiciary at every level, including flat out disobeying the highest court in the land and threatening to impeach and remove judges who do not rule in their favor. Pam Bondi and the director of the FBI in just the opposite direction, defending the arrest, telling the news outlets that escorting a criminal defendant out of back door will not be tolerated. It doesn't matter who you are, she says, you're going to be prosecuted. And indeed, no one is saying that judges, presidents, members of Congress, prosecutors should be above the law. No one should be above the law. And if indeed there is a basis for this return of this criminal complaint, maybe a grand jury indictment as well, that is what the process will contemplate.
The concern, of course, is what is the underlying purpose of this? What is the use for which it's being put? And indeed, that is underscored again by the mechanism, the very mechanism for bringing Judge Dugan into the system once that very controversial decision is made. Arrest did not have to happen here. All that had to happen was to reach out from the U.S. Attorney's Office to her attorney, to her directly, and say, we have in our hands a criminal complaint. What can we do? How can we accomplish a reasonably peaceful and uneventful initial appearance? And there is no doubt that Judge Dugan herself, through the attorneys that she has now hired to represent her, would have accomplished that absent the need to put her in shackles and bring her back to the federal courthouse in the way that they did to face these charges. That, again, important to understand today as we go through all of this, and I know it's a lot. It's important to understand beyond that these are charges. They represent a finding an initial finding by a magistrate judge that there is probable cause. But that's what you get when you even present a case to a grand jury. An indictment is not a final judgment. It is allegations that there is probable cause to believe that conduct of a criminal nature has happened. And that's where we are right now. Judge Dugan has said in very measured statements that she will fight these charges, that she believes strongly, as is her right, as is the right of every single criminal defendant in America to maintain, as she does, her innocence. That's a part of our process as well. And that's the reason why this matter is significant in a rule of law analysis as we think about what our government does and does not do, and ultimately, the real purposes behind this. We've talked at great length about the concern that I have had about the erasing of the connection between the Department of Justice, Main Justice, U.S. Attorney's offices, and the White House. That has been completely erased. We know even in the past weeks, the president has referred for investigation to people previously a part of his administration. Just this past week, Act Blue, an entity that provides mechanisms for financial support of Democratic candidates and causes, referring routinely now individuals and entities for investigation and presumably criminal prosecution as well. Here we have the Attorney General of the United States of America, who should be apart from that, arm's length, as has virtually every other Attorney General, now embracing this particular arrest as a codification of the president's policies with respect to immigration. And the picture of the judge presented by the FBI director, the other things that he has said online, variously online, removed and then replaced there, all of those suggesting that this is not truly about the pursuit of justice. This is not an investigation of genuine criminal activity that is prompted by the interest of the rule of law to ensure that we are all in compliance with it, but rather a product of a political avenue, a political purpose, which is to support the president in his political views. That, if indeed that is the purpose and the process behind this particular arrest and this prosecution, should be the focus of condemnation, not just by me, an objection not just by me, but by everyone who is concerned about the future of America and the future of justice in our land. Again, important to understand all of this, important to appreciate what the criminal complaint says, what it doesn't say, and know as well that there will be more. May 15th is the next hearing date. The judge has an opportunity plainly to be present for that. She will be, as will her attorneys. And at that time, there'll be a hearing about whether or not probable cause can be found. And at some point, if this matter goes ahead, a grand jury, the 23 people convening in private in the federal courthouse, they also have to pass on whether or not this case should be charged to the point of a grand jury indictment. All of that's still coming up. And in the meantime, again, the appropriate in the public domain discussion about the role of the Department of Justice, the role of U.S. attorneys, the role, yes, that they have necessarily to enforce the law, to invoke the statutes that are passed by the Congress to ensure that we are safe and secure. And also in the midst of all of that, final point from me, which is the discretion that is vested inside prosecutors, not only to indict and seek indictments and pursue charges in the discretion to make those judgment calls based upon what's in the best interest of the community and the safety and security of our land, but also to do it in a way that makes sense and that is consistent with our fundamental notions about how best to ensure that the rule of law is observed. All of that, a part of our discussion here today on Amicus. When we come back, we'll take your comments, your questions on this all-important issue. Stay with us. This is Amicus Law Review. My name is Jim Santelle, and we have spent the entire broadcast probably talking all about this very local, very important issue that raises issues about how our Justice Department works, decision-making process internal to U.S. attorneys' offices, and at presumably the highest levels of our Department of Justice. The significant takeaway, the importance that decisions about process, whether to arrest or not, to summon in a nonviolent, non-fleeing defendant into court in a non-arrest type situation, those issues, decisions about whether to charge at all of those properly vested in a Department of Justice and in U.S. attorneys who should apply the law to the facts and the facts of law, and not in any way, shape, or form be impacted by the whims of political issues and political debate, partisan views and disagreements out there, including things advocated by the president with respect to larger policy issues. Deterrence, absolutely. Deterrence comes, as I've said before, through the very prosecution itself, and it will come if this particular prosecution advances, not by virtue of a photograph of the defendant, the judge, in custody, but by virtue of what the government says in its pleadings in court to establish, if it does, that indeed there's been a violation here, and sending the message not only to this defendant, but to future defendants about deterrence. That can still happen here, and that is a legitimate purpose of the Department of Justice. It is not to be an arm, to be an avenue for the president or even the attorney general to advocate for partisan policies that are the subject of what? Legislative debate and executive debate. And yes, indeed, sometimes review by appellate courts. We appreciate so much, as always, those of you who have been a part of our conversation, including those of you calling in. Let's get to some of those callers. Let's begin with you, Cornell. You've been on the line for a while. Thank you for your engagement in our broadcast.
Thank you, Jim. Great show. I just want to say I think it was a terrible statement. Bondi said that the judge was deranged, which means mentally ill, and I think that's a horrible statement due to a outstanding judge, and I hope she files a lawsuit of defamation that it's really terrible, and Bondi should really resign because she's violated due process over 200 times, and I'll listen to your comment.
All right. Cornell, this concern about the name calling, right? Again, should be nowhere in our system. I think you're making reference to the Attorney General and certainly the President of the United States of America who've attacked other federal judges out there for their conduct in, again, providing judicial service to America. And the name calling of people like Judge Zinnes in Maryland, Judge Boasberg in the District of Columbia, who are presiding over these immigration cases. Again, the intrusion of partisan politics and policy about which we can all disagree into the judicial process. That's the problem. Cornell, the point could not be more importantly made. And thank you for making it again on our broadcast today. Joe from Madison calling in. Joe, appreciate your participation as well.
Thanks, Jim. Terrific show. Couple 2 points and then one question for you. First off, and from now on, this is how I'm going to lead every discussion about immigration. We could have had a conservative bipartisan agreement on immigration, but
Yes.
Trump didn't want it because he wanted to run on immigration. So
Absolutely.
Therefore, all of this hoo-ha, all of the money that's being spent on this stuff that we're all so concerned about money is a result of that guy's decision. Okay?
There was
Joe,
there was an absolute agreement among the Republicans and Democrats during the campaign to get this done. And it was a done deal. Again, the vote hadn't taken place, but as you just note so accurately, it was ready to go. And the president said, no, this is not helpful in my campaign. And the Republicans backed out. Stunning.
Even though it was a conservative approach toward the issue of immigration, and those are hard to get, and he got it, and they threw it away. Secondly, I'm wondering, Attorney Matt Flynn had said in a previous conversation on another show that in terms of how the Judge Dugan acted, once it's in her courtroom, she's the one who decides who and how things can go in her courtroom. So if she wants to let somebody in a side door, if she wants to drop a rope out of a window to get them out, that it's her courtroom. It's not the courthouse is not her place, but the courtroom is very much her place, and she can make the decisions about that. I'd like your response to that. And the second thing I'd like to ask you about is that Governor Evers apparently sent out a memo to state employees just about 4 or 5 days ago. I didn't get the exact number. There's Scott Bauer has written about this, so you can look it up if you want to, folks. But it basically offered information to state employees stating what they had to do if ICE agents came into the workplace in terms of what they didn't have to deliver computer files or data or anything. And it also talked about judicial areas and said, unless there is a judicial warrant, and it said specifically in Evers' memo, it's a judicial warrant. You do not have to pay. Don't give it any mind. What you need is a judicial warrant. And the question I would ask for you is, as I understand it, under the 10th Amendment, that question about what happens in state places, whether it be, city, county, or, state courtrooms, that is an issue for state management, not for federal management. And I'd love your response to that.
Absolutely. Joe, appreciate as always the comments. You've got them all right. Absolutely. And so some commentary in our last few moments here. Judge Ashley is working on just that very issue, right? That's the policy in which he basically embraces that notion, right? Judges have the right to manage their own courtrooms, court hallways, different situation. The governor's efforts also to ensure that there is a sense of regularity in all this. Do law enforcement have the capacity to make arrests? Absolutely they do. The question is, under what circumstances can we ensure that those things are done with safety and security in agencies of the state government, federal government, and all of that animated appropriately by a sense of the rule of law? That's what it's all about. Joe, appreciate so much the call. Appreciate this opportunity to come to you today. Next week, again, more about the rule of law, the administration of justice in Wisconsin and throughout our nation. Come back for that discussion. Thanks again. Have a good weekend, everybody.